Patrick Reese, the co-chair, Management Caucus. And it is my pleasure to turn over the duties to Administrator Teresa Van Winkle, who is in a beautiful spot.
Oh, thank you. Not taking over the meeting per se. So we'll start with taking attendance, and then we'll move into the adoption of minutes. So we'll start with management. So Patrick is here. And let's see, Tammy is excused. And I see Sarah. Good morning. John, are you on? Okay. And Lynn. I see. Good morning. Okay. For labor, let's see. When Margaret is excused for today, I see Scott. Good morning. And see Matt. Good morning, Matt. And Jill. Marcy, are you on?
Yes, I'm on by phone.
Okay, good morning.
Good morning.
And Andrew is here. So we do have quorum.
We have a quorum to take a vote for minutes?
Yes.
Okay. All right. Did I indicate, you said that you wanted to run us through the minutes? I think that's the only action item that we have. Did you want to?
That is the only item. It's just, it's the adoption of the February 11th meeting minutes.
Okay. Well, I would entertain a motion to adopt the minutes as presented.
So move.
Thank you, Sarah. I heard a second, but I didn't.
Lynn.
Lynn. Okay. Thank you, Lynn. All right. All those in favor signify by saying aye.
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 Any opposed with the same indication? Okay. Motion passes unanimously. Thank you very much. And I believe we would have, do we have another set of minutes? Is that the last set of minutes? There'd be ones that'll be coming at the next meeting?
Yeah, this is the only set you have in front of you for today.
Okay. All right. Well, thank you. I have a draft agenda, and on it doesn't indicate who, but it says I'm going to have department updates and announcements.
You're stuck with me, Mr. Chair.
Oh, okay. Well, no.
Okay. I really don't have much to report. The only thing I have, and I apologize since I'm not in the office building today. I'm relying on pieces of technology to have in front of me. There will be an invitation from the Workers' Compensation Division coming out this afternoon. It's an invitation to a meeting to start the implementation process for House Bill 4138 from the 22 session, in which you all voted unanimously for. This is the time loss bill that was brought forth to you by the Oregon Child Lawyers Association. So the forthcoming meeting is not anything directly related to rulemaking. So it's not like a RAC, a rulemaking advisory committee. It's more like pre-rulemaking advice before the rulemaking process kicks off more formally. So you'll get to that. I do know Sally is here if you have any technical questions on that. Other than that, that's all I have to report. Okay.
Are there any technical questions or any questions from the caucus members or anyone? Okay. Hearing none. Are those all the updates and announcements?
Yes. Okay.
All right. Well, thank you very much. Next item on the agenda is overview and litigation update from the Workers' Compensation Board. And Connie Wald, Board Chair, and Greg Lowell, Board Project Manager, are listed on the agenda that I have. I'd call on them to give their overview and update.
Well, thank you. I'm Greg Lowell, and with me is Connie Wold, and we're going to provide kind of an overview of what the Workers' Comp Board does, and then some case law updates. So I'm going to begin. I'm going to go share my screen, and we've got some slides to show you, and copies of those will be going out to you after the meeting. And Connie's going to kick us off here. So let me get the screen going. Can you all see that?
Yes.
Okay, very good. Connie, go ahead.
Hi, thank you, Greg. Good morning, everyone. My name is Connie Wold, and as Greg said, I'm the chair of the Workers' Compensation Board, and as such, I'm the agency administrator. And Greg is the project manager, wearing many hats, or being like Gumby, reaching everywhere, to mix my metaphors about Greg. And we just thought we would mostly want to hear from Greg about a case law update today. But there are some new members, and I thought I would just introduce myself and briefly talk about the legislative history and the structure of the board. So next slide, please. So as this slide says, and my grade school grammar teachers are spinning in their graves because it says IT' instead of it's, but so true confession. But the board has a complex history, originally created as part of the State Industrial Accident Commission, or SIAC. But since 1977, the board and its hearings division has existed as an independent adjudicative agency. And that independence is part of our system we have in this country for separation of powers kind of thing. Some of the decisions we review are issued by Workers' Comp Division and or anyway, to continue a little bit with the structure, in 1987, the Department of Insurance and Finance was created, and both the division and the board were transferred there. And as of 1993, the current somewhat different structure, but that institution is, of course, the Department of Consumer and Business Services. And in the legislation, in each case, the legislature specified that the Workers' Compensation Board was to continue in its role as an independent adjudicatory agency. And that's what we remain today. And we happily partner with DCBS for shared services, information technology, human resources, and financial services. So this is one of our little slides showing we have two levels. We have administrative, we have the hearings division where we have administrative law judges and their staff who hold due process hearings of workers' compensation matters, and also they hear Oregon OSHA disputes. We also have a great mediation program where ALJs take additional training as mediators, and that program has been very successful, and particularly, I think, in the pandemic, since SARS-CoV-2, it has been utilized quite a bit. And we have a little bit soundbite there that some of our stats, 99% of our ALJ orders were timely issued, 85% of the mediations settled. And the mediations are a good way to resolve not only workers' compensation disputes, but related employment matters and other litigation that can tag along, over which the board doesn't have jurisdiction, but our judges can help those matters to be resolved. So anyway, the board members, as it says on the slide, provide appellate review of the appealed ALJ decisions, also approve settlements called claim disposition agreements, and exercise on the motion jurisdiction, which is for the older claims, and also approve third-party settlements and have jurisdiction of Crime Victim Act cases too, just for a little more. Next slide, please. I don't know, I just like this one. We'll get back there with reopening, but these stars on this map indicate where the board has 4 staffed offices up and down the I-5 corridor, but we have either property sharing arrangements or leases. We've got an arrangement with Umpqua Community College, Oregon Institute of Technology, one over in Ontario with Four Rivers Cultural Center, and other locations, sort of our pop-up locations, because by statute, in normal times, the hearing is to be held as close as possible to where the injured worker lives. So when state buildings are open and we're traveling, our ALJs are traveling to these locations to conduct their proceedings. Next slide, please. Again, this is just a visual of how we are set up. I'm the board chair and agency administrator, the public member. There are 4 other members, 2 of whom come from backgrounds with an understanding of employee concerns, and 2 of the members with a background and understanding of employer concerns. And for the cases, the way our process works, each of the appeals will be decided by a panel which includes 1 from each side. I see the cases, they work hard, mostly they figure it out, and when they do not agree on what the result should be, then the case comes to the board chair, which is my position, for a tiebreaker. But for significant cases, all 5 members will review those. And then below, you just see some of our structure. We have 3 divisions: the hearings division, where we have a presiding administrative law judge. We have our administrative services division and that manager, and nothing would happen without ASD. And then we have the board's managing attorney, and we have Greg as our project manager. And next slide, please. So we do, just to give you a little bit of information about us.
I'm sorry, I raised my hand. Could I stop for just a quick second?
Sure.
Do you mind if I ask a question as you go?
No. Please ask.
Okay. How are the board members selected?
They are governor appointed and Senate confirmed.
Okay.
So people, yes, I apologize. I didn't say that, did I? Just yeah. And so there's an application process and a vetting process at that level.
No, great. That answers it. Thank you for that.
Yeah, you're welcome. And the terms are 4 years in duration. So let's see. So just some features about our proceedings. We provide language interpreters. We contract with really excellent certified interpreter services, and of course, no cost to the parties for our proceedings. We're quite proud of our interpreter program. We do provide electronic access to the parties through a web portal, which we are constantly seeking to expand. And in non-COVID times, as I showed you on the map, you don't have to come to the Valley to have your proceeding. We come to you. During the SARS-CoV-2 pandemic, COVID-19, the board pivoted almost immediately when the governor's initial executive order was issued and to telephonic proceedings, and then proceeded to ramp up and use, with the help of our folks at DCBS, acquired video conference technology and distributed the necessary equipment. And so as of September 2020, since then, we have done both telephonic and video conference hearings and mediations. And we're currently in the process, as everyone is, of figuring out how to reopen. And the parties have told us, please don't take away our telephonic and video conference options. But they also do want in-person proceedings. So it's an interesting time. I'm quite proud of how we've all weathered this last 2 years. And I think that's the last slide, right, Greg? And anyway, it's a pleasure to meet you. Please feel free to reach out to me at any time with questions. This was just sort of a hi, nice to meet you. And this is our structure. So thank you very much.
Thank you, Connie. That was very educational for me as a new member of the committee. So thank you. Nice to meet you virtually. So.
All right, I'm going to jump into some case law, and I'm going to begin by talking about some of the impacts that were created through the 2022 legislative session, the bills that you folks all worked on, and I will also talk about some cases that involve some policy-related matters, and then kind of give you some highlights of where some of the active litigation is in workers' compensation. I apologize in advance. Some of this is going to have some jargon involved, but you guys are familiar with workers' compensation and jargon and so forth, but feel free to speak up and ask me a question if I've not explained something sufficiently. So first of all, talk about survivors' benefits, House Bill 4086. This has some impact on some case law. We had a case in 2021, Antonio Mendoza, where the claimant and the decedent, the claimant being the surviving beneficiary, they lived together in California, and the decedent would travel to Oregon for jobs. This denial of benefits was upheld because the claimant and decedent had not cohabited in Oregon for more than a year prior to the work fatality. Concurring opinion from one of the board members noted that the policy purpose on survivors' benefits was to protect the family unit, and the cohabitation requirement in Oregon produced some unfair outcomes, especially in kind of modern times where workers oftentimes commute from their home to other states. This is the statute that was in effect at the time, and as you can see in the very top of that statute, what talks about individuals who have cohabited in this state as spouses who are married to each other for over 1 year prior to the date of an accidental injury. That italicized language was removed in House Bill 4086 So it would have some direct impact on this particular case precedent. Another case involving survivors' benefits from 2020, Herbert Williams. This is one where the claimant and the decedent were not married but lived together with the claimant's 3 children from a prior relationship. And the board affirmed a denial of benefits on this case based on some case precedent, which had interpreted the phrase children living as a result of a relationship. But the board urged the court or the legislature to do some fixes here, felt that it was discriminatory to same-sex couples, among other reasons. There was also a dissenting opinion from one of the board members that the board should not apply a precedent that could be unlawful or unconstitutional. This was a case where all 5 members of the board participated in. It was affirmed without opinion by the Court of Appeals, and the Supreme Court denied review. Again, here's the statute that was in effect at the time, and in the underlined italicized part, that little phrase right there was the deciding factor, whether the children were living as a result of that relation. And as that phrase was interpreted in the case law, which went back many years, as a result of that relation had to do with a sort of a biological, the children were biologically related to the couple. Same-sex marriages and other things, sometimes, the biological relationship is a little bit different, and that was the controversy here. Again, that italicized language was removed in the House bill. Talk a little bit about the impacts of 4138 on TTD benefits. A case from 2019, Johanna Southard. This was a case involving the medically stationary date. The attending physician in January of 2018 looked back and said that the worker was medically stationary 6 months earlier, back in June of 2017, and that was the way the closure went. And although the attending physician's chart notes didn't say claimant was medically stationary until January 18, the attending physician expressly agreed that claimant was medically stationary 6 months earlier. A concurring opinion from the board noted that physicians can only authorize temporary disability retroactively for 2 weeks, but there was no prohibition on a retroactive medically stationary date. So you folks obviously heard all about this in your discussions about House Bill 4138. And now the limitation on retroactive medically stationary is 60 days, so they can't go back 6 months like it happened in this case. There was also a long ago case called Carl Mank from 2001, where the insurer paid temporary disability benefits based on authorizations from a physician assistant. And they have a limitation in the statute as to how long they can authorize benefits. So in this particular case, 5 months of the disability benefits that were paid were considered an overpayment because the physician assistant's authorization period had expired. And also the attending physician, the medical doctor in this case, could not go back more than 14 days. So that is also has been addressed in House Bill 4138, which has notice provisions and some expanded retroactive authorization of temporary disability. And then finally, just a little kind of a footnote here about overpayments. Historically, overpayments had been established by a notice of closure. So a closure awards periods of temporary disability, and then if there was anything paid after that, the insurer could take an overpayment and reduce perhaps the permanent disability award or take future credit. There was a case in 2019, Court of Appeals case, which established the idea that because the insurer is seeking an overpayment, they have to prove that. And you can't just point at the notice of closure. You might also have to establish that benefits were properly terminated. So it kind of allows the look a little bit behind the closure to determine whether the overpayments were warranted and whether they could take credit for it. And again, you've done some, you've addressed overpayments in House Bill 4138 as well. So I'm going to turn to some policy-related cases that are, I don't know if they're on your plate or not, but Kara had asked us to discuss other cases in which board members had offered concurring opinions or that involved policy-related matters. So one of them is the claimant's cost reimbursement. There's a statute in place where if a worker prevails on overturning a denial, they can seek reimbursement of costs. And costs are things like obtaining a medical report, arranging for witnesses, other kinds of costs you might have to spend to get to hearing and to prove your case. There was a decision, this one goes back several years, but the most recent decision on Kevin Segrist came out in 2020, and it involved this reimbursement of costs. There's the statute. The reimbursement limitation is $1,500 absent extraordinary circumstances. This case, the denial was set aside, and the claimant submitted a cost bill for $1,550, so $50 over the threshold, and that was based on getting a report from a physician, and that was the amount that they had to pay to get it. So the board originally found that to be extraordinary circumstances and awarded it. It was remanded back by the court for further explanation, and then on remand, the board noted that yes, although it may be necessary to spend the amount of money that they needed, and it may be necessary at times to go over that $1,500 threshold, it doesn't always make it extraordinary. A concurring opinion noted that this is a 2007 law. The 1,500 was put in there after negotiation among MLAC and the legislature, but that 1,500 would approximate the expense of securing a report, but 15 years later, you can commonly exceed that threshold. And the suggestion was perhaps a cost of living allowance or some way to kind of have this threshold rise with, as expenses go up, noting that if that had been applied, we'd be up to about a little over $2,000 in 2020. And the concurring opinion also said, consider expanding access to worker-requested medical examinations. That's the acronym that unfortunately has the name wormy to it, but to include any situation where a carrier uses a medical opinion in support of a denial. I'm sorry about that. That was my phone. So let me talk a little bit about worker-requested medical examinations. This is a law that allows a worker to get an examination report done and a report at the expense of the insurer in a circumstance where the insurer has issued a denial that is based on an independent medical examination where the worker's attending physician does not agree with that medical examination. We had a case, Thomas Cardoza from 2019, where the request for a worker-requested medical examination was denied. These cases start at the Workers' Compensation Division. They're the ones who approve or deny the worker-requested medical examinations. In this case, the insurer denied the claim and then obtained an IME, which concluded that the work was not a cause of the low back condition. So the statute here, as you look at it, and I want to kind of focus on that italicized language there, it involves a situation where a denial is based on one or more reports of examinations, referring to IMEs here. So as you kind of look back at that bullet point above there, the argument here was the denial was not based on an examination because the denial issued first and then they got the examination. So this went through litigation and the board affirmed the decision to deny the wormy exam based on the language of the statute there. Meanwhile, Claimant tried some other things, tried to have the IME report excluded or require the carrier to amend its denial. and although the board said, well, the denial didn't state it was based on an IME, there was no particular authority in the rule or in the statute to exclude the report from the record. Furthermore, a case from 2013, the worker requested medical examination is not available when that IME is a record review. And so if you go back up and look at that statutory language, it talks about the denial being based on one or more reports of examinations. So that has been interpreted to mean a physical examination, not just a record review. Another case involving the notice of closure appeal deadline. This was Juan Lopez Ciro from 2020. This is one where WCD denied claimant's request for appeal to get a reconsideration of a notice of closure because it was filed after the expiration of the 60-day appeal deadline. Here's the statute. It talks about that last sentence, a worker's request for reconsideration must be made within 60 days of the notice of closure. This statute does not have a good cause exception, which we see in other similar type statutes, like at a request for hearing or whether the worker provides timely notice of a work injury. There are oftentimes good cause exceptions to deadlines. There is not one in the reconsideration of a closure statute. Okay, so those are the policy-related cases I wanted to talk about, and I may be going a little bit long in my time. And Teresa, if we need to move on, just give me the heads up. I've got, but I'm going to cover some cases that kind of hot areas of litigation from what I can see on board review. And again, we're always a little bit behind what might be happening at the hearings division. But combined,
Sorry,
yes.
Greg, I have a quick question. Do you mind going back I just wanted, what would be just an example of a good cause for the 60-day appeal deadline?
Well, good cause is something that often comes out of other areas of law, and I think the correct quote is inadvertence, mistake, or excusable neglect.
Okay.
And those have particular legal terms that are applied to facts of cases, but there are some recent workers' comp cases involving good cause where the court has said that should be liberally construed in favor of the worker, and that the idea being let's try to get to the merits of the cases rather than not pull out on procedure.
Okay, great. Thank you.
So combined conditions, obviously a hot area of litigation. And one of the things that's happening right now is what is a combined condition? And this is typically involving what we're talking about is like a pre-existing condition, which has a legal, there are legal standards for what a pre-existing condition is, something that's been previously diagnosed or treated, or is an arthritic condition, and then it can combine with a work injury. And the board has, from 1999 forward, applied the standard under this case called McAtee, where a combined condition can be two medical problems that occur simultaneously. In 2017, a very important Supreme Court case, Brown v. Safe, said that in the context of a denial and a combined condition is two separate conditions that combine. There's a little bit of an exception for initial injury claims, but let's give you a good example here. In Ariano v. Safe, 2021, this is a low back combined condition claim, and the board found that the two medical problems here were spondylosis, which is like degenerative disc disease of the back, and low back symptoms combined to create a combined condition. The court cited its own decision in Carrillo and said that a pre-existing condition and its symptoms are not separate conditions. So why is this important? When you're in the combined condition area, if the major contributing cause standard applies. If you're outside of the combined condition area, the material contributing cause standard applies, which is a lower standard and easier standard for a worker to meet. So they said this was not a combined condition and remanded it back to the board to address that. Let me give you one more example, and I realize I'm a little bit in the weeds here on combined conditions. This is Gibson v. ESIS, a recent case where the board upheld a denial of a combined knee condition, and the parties agreed that osteoarthritis was actually the major cause here. But the question was, is this a combined condition? What are the two separate conditions here? And the employer made an argument that new and old conditions can merge and qualify as a combined condition. So the question was really what combined with the osteoarthritis? And here are some of the possible explanations that came out of the record. Symptoms of a hyperextension, pain, exacerbation, and ultimately the court reasoned that none of these amounted to a separate medical condition and reversed and remanded it back to the board. I know you guys spent a lot of time looking at COVID over the last couple of years. We don't yet have a appellate decision involving COVID, but I do want to bring your attention to an infectious disease case that came out this year, Rogers v. Corvell, and it was a bus driver with influenza A, and the attending physician cited studies that public transportation drivers have all this exposure to the public and are at increased risk for infectious diseases, but the denial was upheld because the board found that the attending physician was unaware of claimant's other activities, such as outings to the grocery store, where she could have been exposed in the days prior to the onset of the illness. The Court of Appeals reversed and remanded this, noting that because the claim was litigated as an injury, it falls under the material contributing cause standard. An occupational disease might be a major cause standard, but for purposes of addressing material cause.
My bad. In that MLAC meeting.
The question is that they put back to the board, is it more likely than not that the employment is a substantial cause that is more than a minimal cause of claimant's illness? So again, this is not a COVID case. It might have some applicability to a COVID case because it did involve an infectious disease. Some of the more interesting things about course and scope cases. These are cases where they're not medical disputes, but they're kind of factual disputes as to whether the worker was in the course and scope of their employment when the injury occurred. A recent case, Miles v. Weimart. This is a worker who was parked in a designated employee parking area and while walking into work tripped on some broken pavement. So one of the principles in workers' compensation is that you're typically not in the course and scope of your employment when you're commuting to work or commuting home from work. The workday hasn't started, but there are some exceptions, and one of these is the parking lot exception to the going and coming rule, and that typically involves a situation where if it's the employer's parking lot, then you've arrived at work, and you would be in the exception to the going and coming rule because the employer has some control over the premises in which the injury happened if it's the employer's parking lot. So you get into disputes as to when is it the employer's parking lot and when is it not. And in this case, the board upheld the denial, relying on the employer's lease, which assigned the landlord, not the employer, with responsibility for the parking lot. So this is Weimart leasing space, and the landlord controls the area outside the store, the parking lot, and the board upheld the denial on that basis. They went to the court, and the court noted other relevant factors that should be considered. One of them was that the employer could restrict the employee parking to designated areas, which is what happened here. The employer could request maintenance and also outlaw activities such as skateboarding. So the court said the employer had some control over the parking lot, and that was enough to provide for the parking lot exception to the going and coming rule. They also noted that there was some employer benefit in the designated employee parking by allowing customers to park closer to the store. So that was reversed and remanded, came back to the board. Another case, Watt v. Safe, and this is not a parking lot case, but involves a little bit of an off-premises injury where the worker was on a walk during a break, part of the employer's wellness program, and fell over a cracked sidewalk in a residential neighborhood. So you've got an off-premises injury, but you have a little bit of employment connection there with the employer's wellness program. And it's not before work or after work, it's during the workday, during a break. So what was applied here, one of the things they looked at was what's called the personal comfort doctrine. And this is a situation where, for example, like in our building here, the bathrooms are actually kind of outside of our leased area, but I don't walk in and out of my course of employment by going down the hall to the bathroom. And so the court has recognized over the decades that personal comfort activities, getting a drink of water, you might have a construction site where the only bathroom is across the street, that you don't go in and out of your course of employment if you're just attending to personal comfort. And course of employment refers to the time and the place and the circumstances. So in doing so, the court went back into some old case, more recent case law, and said that the personal comfort activity does also require a secondary analysis of the arising out of the risk of employment. That's the two prongs of course and scope. Course of employment and arising out of employment. And actually, they usually referred to in the reverse as AOE and COE, arising out of and in course of employment. And ultimately, the court agreed with the board that the sidewalk itself was a neutral risk. The employer did not require the claimant to leave the premises, although they had a wellness program, and they didn't dictate where they had to walk. So it was not an employment risk, and in this particular case, the denial was upheld. The employment did not expose the claimant to the cracked sidewalk. All right, permanent disability is getting to be a very complicated area because it's always been a complicated area. But there was a very important case called Karen v. Providence from 2019. Just to get to the bottom line here, workers are to be fully compensated for impairment due in material part to the injury unless the employer issues a combined condition denial. And I'm not doing justice to the complexity of all this, but I will try to give you some highlights here. So traditionally, going back to 1960, that material cause test has been in place. And then in the statute, there's a phrase that talks about impairment due to the injury. What does due to mean? We've got some case law from 1985 that the court cited that says if an injury causes a pre-existing condition to light up, then that can be due to the compensable injury. Combined conditions are the exceptions where the carrier can accept and then issue a denial of a combined condition to be able to apportion disability to pre-existing conditions. The employer has the burden of proof on a combined condition, and the court pointed out that when the carrier goes through that combined condition denial process, that it gives the claimant notice and allows the claimant to appeal that. So the idea that the court looked at was you can't deny the worker some of their impairment compensation without issuing that denial, without providing some notice and giving the worker a chance to challenge that. There's a case that came out in 2020 where the issue was loss of grip strength for a hand injury. And in part, some of that grip strength was due to a denied shoulder condition. So the board allowed the carrier to do some apportionment. The arbiter noted that strength loss was due to a combined condition, but the carrier had not actually denied the combined condition in this case. The Supreme Court remanded it back to the Court of Appeals to consider it under Karen. Karen did not specifically address this particular fact pattern, but ultimately the Court of Appeals ordered the worker to get the full permanent disability award because although the carrier had denied the shoulder, they had not issued a combined condition denial that resulted in that range of motion impairment of the hand. The Johnson case is on appeal. The Supreme Court accepted review, so more to come on that one. Robinette v. Safe is also awaiting review at the Supreme Court, along with the Johnson case. And this is one where part of the claimant's impairment findings were due to conditions that were not identified until after the claim was closed. And it was unclear whether these are what's called legally cognizable pre-existing conditions. But none of the range of motion loss or instability were attributed to the work injury. But the Court of Appeals, citing reasoning from the Karen case, said that the claimant is still entitled to notice if the employer is going to contend the impairment is not compensable. They didn't issue a denial in this case. Even if there's not a combining, the employer needs to put the worker on notice that there's going to be some sort of denial of benefits, permanent disability benefits. Because there was no denial issued, claimant was entitled to the full PPD award. So that is also up at the Supreme Court. Both of those cases, they may be decided in tandem, not sure, but stay tuned on that. I'm sorry, I'm going over my time. I've got one more case to talk about involving claims processing. This is a case that an injured worker without an attorney, pro se claimant, filed a hearing request. That denial was rescinded after the claimant obtained an attorney. It started out with litigation about whether the attorney ought to get an attorney fee. Ultimately, the board said, well, the attorney was not really instrumental in getting that denial overturned. It had to do with the rescission following the IME. But it came to the court, and the court sent it back on the penalty issue as to whether it was an improper denial. And the board ultimately awarded a penalty, citing a WCD rule that legitimate doubt over the compensability of a claim does not exist without a reasonable investigation. They didn't feel there was a good faith effort to obtain information about the claim before it was denied, and awarded a penalty on that. So that penalty decision came out in 2021. It may have some impact on claims processing. Okay, I'm going to just close with some fun cases, and hopefully you'll get I don't know if these are fun or not, or just kind of scary, but how about this one? Ralph Dunnington, a respiratory condition, was found not compensable despite this worker's exposure to particulate matter that included dust and rat feces without wearing a respirator or mask, because the claimant's bacteria was not the type found in rat feces. So, boy, some interesting facts there. This was a fun case to Thomas Auckland. Comparison of claimant, the board made a comparison of markings the claimant made on a pain diagram, arguing that this disproved the claimant's theory that he had a decline in symptoms when off work. Aha. But it turned out those markings included a large section of notes and shorthand medical terminology that did not appear to come from the claimant himself. And then we had an odd one here, Joaquin Quintero. The doctor had signed 2 concurrence letters, one saying the injury was the major cause, and one that it was not even a material cause. Sometimes doctors change their mind, but both of these letters were signed on the same day. The doctor was found not persuasive. I am done with my slides. I appreciate all your patience. I know I went a little over my time, but I'm happy to take any questions you might have.
Thank you very much, Greg. That was very informative, and it really put perspective on a lot of the discussions we've had earlier. And I see the gallery view. I don't see any hands raised. There is one. Scott.
Hi, yeah, Scott Strickland. Would it be possible to get a copy of those slides by chance, just to be able to review and kind of look up some of the cases and see the history and whatnot as well? Would be, I think, very helpful.
Yes, I'll get a copy over to Teresa and Kara, and I believe they're going to send those out.
Yep,
Great,
thank you so much. Yep, we will take care of that after the meeting.
Excellent, thank you.
Teresa. Matt, you've got your hand up.
Matt Kelsey with the Oregon Nurses Association. And I was just wondering if there are, on the docket, are there many COVID-19 cases coming through that you're aware of?
I don't know. Yeah, I don't. I'm sorry. I wish I knew something on that. I only see them when they come out. So if they're in deliberation, I would not know about that yet.
All right, any other questions? Well, we do have 4 presentations coming up, and I know that I don't know if you went over or not. I'm not sure. It went quick, and it was very informative. So thank you very much for your time, and hopefully we'll have regular updates from your group at our MLAC meetings.
Glad to do so. Thank you.
Right, the next item on the agenda is informational sessions. This is on managed care organization, and it fits with our work plan as a committee. And we've got 4 different presentations, and starting with Ann Klein from Majora's Health Systems. And so I will turn it over to her. Thank you for attending today. You're on mute, although it doesn't show mute, Ann. I don't hear you. No, I still don't hear you. I see. Yeah, I don't know if you want, Ann, for somebody else to go first, and then you can kind of work through some of the technical things. I don't know how to help you. I don't know. Teresa, do you have any advice or?
I don't, except perhaps to call in into the meeting as well. But we can go on to the next presenter while we'll figure out Ann's tech issues.
We'll go to the next presenter, which on my agenda is Kaiser on the job, and I think we just learned our speaker is James Washburn. So James, are you on the line?
Yep, I'm on the line. So just wanted to give a quick overview of the Kaiser on the job.
Well, James, I can hear you, but it's very muffled, and I don't know, the quality of the sound isn't great for me.
Okay. Let me work on mine, and then I will help.
Okay.
Better?
That sounded better.
Yeah,
promising.
sorry. Yeah, and one thing I'm finding with mine is I had to go back in and select my microphone and speaker in order to get the headset. So,
okay, good tip. Thank you, James.
Yeah, so let me give you a quick overview of the Kaiser on the job MCO. I know Ann was going to give a further overview on MCO, so I'm just talking about our own organization. So, Kaiser Permanente was started. Has a proud history of supporting injured workers. We were started by Henry Kaiser, the industrialist, along with Dr. Sidney Garfield, to support workers and their families with the construction of the Grand Coulee Dam in Washington. And then we later expanded to the shipyards in Portland during World War II. So long history of working with injured workers here. We are a managed care organization. We were started back in 1991 as an MCO. We were certified by the state then. Our services are backed by the facility and staff of Kaiser Permanente. We are an integrated and managed care organization. Our MCO panel includes the physicians of Kaiser Permanente, along with many of our contractor providers are also part of our panel. Our overall goal is to assure high quality, cost-effective treatment and minimize functional impairment through timely return to work. We service the Portland and Salem metro areas, so we are actually probably the smallest MCO and only cover those service areas. We are open to members and non-members, so approximately about 25% of our injured workers that we're seeing are non-members of Kaiser. So at times that's been surprising to people. Our MCO patients can be seen at our 4 occupational health clinics located in the Portland, Salem, and Vancouver area, or at any of our Kaiser facilities. So again, Kaiser has occupational medicine physicians, but it also injured workers can see many other Kaiser physicians, such as their primary care physician for injury care, where the primary care physician can act as the attending physician. We have access to 24-hour care through our emergency departments and urgent care, as well as many virtual options within Kaiser. And that is all I have. Are there any questions?
Any questions for Mr. Washburn? Let me scan through. I don't see any hands raised. So I will. We might have some at the end because, as you said,
that's fine.
You were a follow-up to the overview, so we may learn in our overview things that we want to ask about later. So we'll wait for that. I see Ann. Do you think? Have you got it? See if I can hear you.
Well, testing 1, 2, 3.
Yes, I hear you. Great,
okay.
Great. Okay.
I called in. I'm sorry about that, guys. And yeah, I was tasked with the overview, so I'm sorry, James, that I didn't set you up as intended. But let me share my screen, and we'll see if we can get back on track.
Okay, thank you.
Confirming you guys can see the presentation?
Yes, I can.
Great. Well, thank you for the time to come in and provide some information regarding managed care organizations in Oregon. My name is Ann Klein. I'm president of Majoris Health Systems, and we are one of the 4 currently active certified managed care organizations in the state of Oregon. And what I'm hoping, it's a lot to provide an overview. I will do my best to stay succinct. It will likely mean that I won't delve into everything at the level that maybe could be hoped for, but my initiative here is to provide a good framework so then the committee can identify those topics of interest that you really do want to dive into in more detail. And there are also, as my disclaimer, each MCO, while we're regulated by statute and rules, we do have the ability to make decisions in our specific processes and protocols. So I'm doing my best to call out when I know that it's unique to Majoris element, but luckily I also have the other MCOs here, so if I inadvertently misrepresent, I hope they will correct anything that I misstate. So to get started, I wanted to start with a history of why is there managed care in Oregon and when did it enter into the workers' compensation system. And we actually share an origination story and history with the Management and Labor Advisory Committee. We came out of the same set of reforms that are now known as Mahonia Hall. So as I'm sure you're aware, before those occurred, Oregon was really struggling as a workers' compensation system to meet the needs of Oregon injured workers and employers. And so that prompted reform and members from both the management and labor side coming together to identify a series of recommendations to rebalance that system and deliver to the Oregon workers' compensation system several core goals, which are the same goals that MLAC as well is tasked with. It's just the overall framework. That these reforms are meant to provide balance, adequacy of benefits, affordability, efficiency, stability, and flexibility. And the MCOs were one of those key pillars in the recommendations to add in managed care into the system. And as you can see with this graph, following those reforms, the Oregon workers' compensation system really made a dramatic turnaround, going from the 6th most expensive in the nation for workers' compensation premiums, which is representative of the overall cost of the system to deliver benefits, down to the 5th least expensive in the nation in 2018. Another way to look at that data and measure success of the system is the overall total annual cost of benefits, both on the medical and indemnity side, there is some increases, but overall have held despite the fact that benefits enhance, and we always are facing the inflation element that always is not only ongoing but ever upward. And so another demonstration of the overall reform success. And ultimately, with all of it, the stakeholders that are in the workers' compensation system, and when I say stakeholders, employers, injured workers, insurers, attorneys, the treating medical providers, and other entities like managed care organizations, we're all here in the system with one shared objective, and that is to ensure that workers are being provided high-quality care that's recovery-focused, while at the same time avoiding unnecessary care, and providing all stakeholders the information that they need to fulfill their obligations in the system. Everybody does have a role to perform in order to provide a system that is not only there for injured workers in current times, but providing those robust benefits in such a way that we can also expect that we'll continue to be able to do that for future generations. And so with that shared objective, NCOs entered in the statute outlines specifically what does managed care in Oregon need to do to succeed in achieving those goals outlined and providing the high quality medical care to injured workers. And so we came up with some functions. I'm not going to go into a lot of details here. This is really just high-level paraphrasing to what's directly in the statute. But they did identify that each NCO, in order to be considered valid and certified, must have a plan design that delivers these core functions, which is peer review, utilization review, quality assurance, dispute resolution, and contract review. So these are all important legs. There's one that I'm going to call out because it's an element that I think I see confusion in regularly, and it's that with utilization review, the NCOs are tasked with providing requests and recommendations, decisions on medical necessity. And the medical necessity is focused on, is the proposed treatment medically appropriate and necessary, supported by evidence-based guidelines for the diagnosed condition. NCOs do not address compensability. On the other side of that, we have insurers. They are focused on addressing compensability. Is the proposed treatment directed towards a compensable work condition or work injury? They do not address medical necessity. Each of those are their own bucket, and the goal is that each is focused on their core area of expertise. And overall, the broad concept is that they introduced managed care in order to ensure that medical decision-making was based within the medical forum. But I'm going to quickly shift more to saying, so what does statute look like in practice? And there are what I would consider three broad categories of services that the managed care organizations provide. The first is the medical case management and utilization review. And the MCO initiative is to support timely injury resolution by ensuring the care provided to injured workers is necessary, appropriate, and recovery-focused. And again, this is where my disclaimer comes in. Each NCO is going to have their unique processes and protocols on how to meet this initiative. But broadly speaking, there should be broad medical case management. This is looking at the overall treatment and disability status of injured workers, monitoring to identify and resolve barriers, ensure that they're being seen at the appropriate level of care, and providing assistance to facilitate getting into appointments and ensuring that care is moving forward. And that also includes providing education to treating providers. There's an additional nuance to treating workers' compensation patients versus others, oftentimes with a similar injury, but just don't have the additional legal framework that does come with work comp. And so the education there to help them navigate can also be important. Then drilling down underneath that medical case management is the more direct utilization review function, which is looking at the specific treatment that's being proposed. And utilization review is set to be performed by medical providers. It is expected to be supported by established guidelines. Majora specifically is looking for whenever possible, not just evidence-based, peer-reviewed guidelines, but also those that have, when available, look specifically at the workers' compensation patient population, because there's sometimes differences there, and always supported by objective findings. And then going a higher level is ongoing quality assurance, which is an expected function of the MCOs. This is more of a broad review of trends. Those trends could be in the overall pattern of care and outcomes for an individual medical provider. It could also be broader trends within the workers' compensation system or overall healthcare system. Things that I would call out as recent, semi-recent in history. One would be opioid treatment. These days, hot button topic. Nobody would bat an eye to have a question about whether or not opioid treatment is appropriate. We're much more conservative in the use of it. 10 to 15 years ago, that wasn't the case. But we identified a trend where it appeared that opioid medication as a treatment for pain was not serving injured workers. And we were seeing long-term negative impacts and transition to dependency on a chronic level. And so the MCOs are in a good position to take that from a medical standpoint and identify, are there protocols that we can introduce to better manage this utilization and ensure improved worker outcomes, that they're receiving appropriate care. And then other areas include Majoris is certified throughout the state, so there are different communities and different needs. We often find ourselves partnering with those more rural communities who face a shortage of providers, not just for workers' compensation, but broadly, and finding opportunities to innovate and partner with them without undermining quality of care for the workers, or identifying trends and changes in specialized care, what's available, and introducing that in and innovating, while also making sure there's good parameters in place to ensure that proposed treatment is still supported by those peer-reviewed guidelines and evidence-based medicine as a whole. The next kind of broad category or pillar of the MCO concept is the provider network itself. The MCO initiative here is to maintain a network of providers for workers' compensation patients that meet defined quality standards. The network makeup is going to be focused on workers' compensation. Each MCO will determine what makes sense for them and any other considerations that they have. They do have a baseline. Statutes outline minimums for provider count and specialty by geographical service area to ensure appropriate coverage, but the MCO still has ability from that to decide what's the best way to curate those lists of providers to ensure that workers are being provided the best choice to determine who should be providing their care as attending physician or specialist or ancillary care provider. And that then brings us to that piece of credentialing. MCOs have that knowledge, the tools, and authority to review medical practitioners and confirm they meet quality standards. There's some elements that are available to the public, but most of the public are not familiar with utilizing them to assess how is this medical provider, what does their malpractice history look like, do they have any board action. Majoris specifically also looks at workers' compensation treatment patterns from past cases. Do they understand the other elements that come with treating workers' compensation, addressing physical capacity, ensuring that the mechanism of injury is documented to help provide the insurer the information they need to make compensability decisions? Do they recognize the need to compartmentalize, even if the leg bone is connected to the knee bone? One of them may be compensable and part of the injury, the other not, and documentation to help keep that clear is key. And then there's also other services that are not available to the public, such as the National Practitioners Database. That requires you to be a specific type of entity registered with them and pay for the services in order to perform certain credentialing actions and activities. And the other piece of this is provider accountability and support, and I put them very much together side by side. The MCOs contract with providers to agree to follow certain protocols and treatment guidelines that are set to ensure best practices in the treatment of injured workers. And we hold those standards high and hold our providers accountable to them, but we do it in a collaborative partnership way the focus is to provide them the tools, the information, and general support in order to navigate those elements and ensure that we're all, again, meeting that shared objective of quality medical care provided to the injured workers. And then the last piece is dispute resolution. The MCO initiative here is to resolve disputes efficiently, utilizing objective medical data, evidence-based medicine, and peer-based oversight. The dispute resolution piece is regulated, again, by statute and rule. All parties have the right to appeal any decision made by the MCO. But the real helpful piece when you look at MCO disputes or disputes when they're subject to the MCO is there's very clear timelines and expectations of how this process should work. Appeals need to be made within 30 days of a decision, and then the MCOs have 60 days to respond to that appeal. It's very clear expectations of process. So for Majora specifically, appeals related to medical treatment are heard by a medical review committee. There are occasionally some appeals that are really purely administrative in matter. Those are few, but in those cases, they may be heard by an administrative review committee. I would expect all of the other MCOs will have a very similar construct. They may just choose to call these things differently, which is why I call it out as, I don't know what their fancy title is for the various committees. And then last, and I know that I'm going to try to be as succinct as possible, but I have two elements that seem to be very common with questions on how the MCO works. The first is the enrollment process. How does an injured worker get enrolled? How do they know what happens next? So notice of enrollment must be written and sent to the worker, including appeal rights, and is effective 3 days from the date of mailing. All other known parties are copied to this notice. So that would include the adjuster, the any known treating providers, an attorney if there is one, would be the most common of those parties copied. And another piece that commonly comes up is it doesn't seem like workers are enrolled at the same time in their from their date of injury, and that is true. Enrollment is not a specific targeted time in the regulations. Instead, enrollment timing is determined by each insurer with the contract they have with the MCO to best align with their processes and needs to ensure that it's an effective match. MCOs are looking to supplement and enhance the other elements and other stakeholders' obligations and roles. When that happens, the worker is then going to be directed into network. If they're already currently treating in-network, they're simply told that's the case. They're treating with a qualified in-network attending physician, no change. If they're not, they're provided instructions on how to find a network provider, as well as how to access the MCO to request assistance if they need it. And there are times where non-network care is available. Automatically, at time of notice, workers have 14 days where they can continue to treat off-panel to provide them time to transition into network and make their selection from the network provider listing. There are also certain providers that qualify for come-along privileges, and these allow the worker to continue treating with a non-network provider so long as the non-network provider agrees to follow the MCO rules and protocols for the treatment of that specific injured worker. This piece, the MCO handles identifying and facilitating. They're the ones that have the best knowledge of when and why somebody would qualify. And then last is a couple other scenarios where moving them directly into network may be disruptive. I think the most common and straightforward is the global surgery period. If they've just had a surgery performed by a non-network surgeon, it's not going to make sense to try to transition them in network right away, but rather wait until the global surgery period ends. And there can be other times where a worker's in a course of care where it's determined to allow them to finish that out before directing in network. And the other piece is treatment pre-certification. I won't go into a lot of detail because you will be provided these slides at the end, but broadly speaking, how do they know when to submit pre-certification? Providers are contracted with the MCOs. They're aware of the protocols and procedures. If it looks like they're missing something, the MCO will reach out proactively to note that. And providers are notified when a worker is subject to the MCO rules, so they know to check that box as they're moving forward. Each MCO MCO is going to set their own process for how they would like those requests submitted. In Majora's case, we have an online prefix system that provides intuitive forms that prompt what information is needed depending on the procedure they're requesting, and also allows them to check status, reprint documents, and also quick access to the individual claim representative that's assigned to the claim on Majora's side if they have questions. Our goal is to have a decision issued within 24 business hours from receipt of a complete request. There are times where that doesn't happen. Most commonly, it's because we're looking for additional information that's missing. And that takes me to the last piece of decision making. Each MCO is going to have their own review process. Majora's utilizes physician reviewers to make those medical decisions. We do have a small subset of physical therapy requests that are reviewed by physical therapists. And if there's any questions about treatment being outside of guidelines, the reviewer is going to want to first do additional due diligence to make sure they're not missing something, to reach out to that treating provider, note what the guidelines say, indicate why it appears that it's outside of guidelines, and request information or clarification, and then go from there. Ultimately, the goal, it's not to disapprove care. It's to identify what's the most appropriate care for this injured worker's recovery, and let's make sure that it's care that is supported by those evidence-based, peer-reviewed guidelines that are available. And again, all parties are copied on decisions and provided appeal rights. And then because I threw a lot of information at you, I'm just going to do a very high-level recap going back to the where I started, which was the question of how did MCOs come into D? And that was a response to what are the recommendations on meeting Mahonia Hall's goals of balance, adequacy of benefits, affordability, efficiency, stability, and flexibility. MCOs, by nature, are neutral. They're designed that way. The statute is looking for them to be independent. They can, an insurer, self-insured employer, third-party administrator cannot be a certified MCO. MCOs actually cannot maintain their certification if they go overly long. There's a defined time frame of only having a single insurer contracting with them. And they're partnering with both the medical providers and the insurers to meet that shared goal of providing high-quality care to injured workers. The adequacy of benefits piece is well addressed in setting expectations that the MCO has a clear plan design on how medical benefits will be delivered, and certain expectations and baselines of the minimums in order to achieve that. And we're also subject to oversight by DCBS. That includes having our plan design reviewed, approved, and on file. Any changes have to go through that same process. And any of our provider or insurer contracts, they also need to go through filing with the department. Affordability is achieved through looking again at driving positive outcomes in an efficient manner, looking and ensuring that the care that's being provided is done timely and it's at a high quality level with providers who understand the system. And that does translate into the efficiency piece. There's really a collaborative structure to the MCO, and they're working with both medical providers and the insurers, self-insured employers. And it gives us a unique position of understanding where both sides are coming from to identify and collaborate to have continued improvement processes in place. And I do think as well, just having some very defined outlines of timelines, expectations, documentation, all of that also supports efficiency. And our last is stability and flexibility. The regulated framework really supports stability. We have some clear frameworks that we are operating within that helps maintain consistency. But with our close partnerships with stakeholders and our task of ongoing quality assurance, we're really set to help the system and the way that medical care is delivered to workers to evolve to the needs of the current day injured workers and keep pace with modern medicine and the guidelines that are current. And that is my fire hose of information. I hope that it provided a good overview of what an MCO is and how we work. And I'm very happy to answer any questions either now or after the other MCOs have an opportunity to talk.
See, Sarah Duckwall has her hand up, so we have our first question.
Great, thanks. And thank you very much. Very informative. Just a quick question on how MCOs are triggered. You talked about the enrollment process, but who triggers the MCO enrollment process?
So that will be defined to a certain extent just by whatever the insurer MCO contract outlines. In some cases, the contract may say that 100% of claims are enrolled, and then it may have a defined timeline. It may be at adjuster discretion. There may also be contracts that are structured where it is completely at insurer discretion to make a determination of, I think this claim would benefit from the addition of managed care into the overall processing and support.
Okay, thank you. That's helpful.
I see another hand raised. Go ahead, Ryan.
Yeah, Ryan Hearn. Hi. Yeah, thank you. I'm with Roseburg Forest Products. I saw that you have physician reviewers reviewing the certifications. What are the physician reviewers like qualified? How do you pick them? How are they familiar with the medical field, and making that determination?
Yeah. We look for board certified physicians that have a background in treating workers' compensation. We have a variety of specialists, orthopedists, spine, physical medicine and rehabilitation are the most common that we partner with because those are the most common in the treatment of work injuries. And we're looking again, quite often those that come to partner with us are ones that we first partnered with on the network side, that they treated a lot of injured workers. We grew familiar with them. They grew familiar with us and our processes. Makes a really natural transition into working on the other side.
Perfect. Thank you.
Thank you for the question. Scott Strickland has a question as well.
Hi, yeah, Scott Strickland. Had a question about the enrollment. I noticed that you said there were come-along provisions that sort of vary depending on the MCO and how things work, and that they also would require that the provider agree to kind of go along with that. But there aren't any restrictions in terms of MCO enrollment where if someone is seeing a certain physician or certain provider, that in order to be enrolled, they have to be enrolled such that that provider is automatically also enrolled, or that can only be enrolled in an MCO that has that provider as well. I guess there's no restrictions in the enrollment initially, correct?
If I'm understanding your question of if there's any restrictions in enrolling somebody into an MCO because they are treating with a provider who is not in that MCO, you are correct. I do want to clarify that when it comes to the come-along privileges, that specific piece, and I can see where the way I framed it would be confusing, that specific piece is actually very clearly outlined in the statute. So who qualifies for come-along is going to be consistent from MCO to MCO. And the most common reason for qualification is that they had established with that provider as their primary care physician prior to injury. So that's going to be the most common reason. There are a couple others. And then there is also the ability for a referring provider to request the authorization, pre-certification to refer out of network and provide medical justification for why that out-of-network provider should be utilized instead of an in-network provider.
All right. Ryan, did you still have your hand raised from before, or do you have another question?
No question here. Sorry about that. I'll take that down.
Okay. I have one question, just it's in an overview format. You talked about challenges in rural areas, with this MCO model. Are there any parts of the state that are not well represented, with this opportunity for MCO?
So I don't think that any part of the state is limited in access to the MCO. There's certainly our willingness to go in and partner, but where there is limitations is there are some communities who have difficult time recruiting providers into the area, and so there's a strain on the overall healthcare system And as we're a part of that, that translates into limited access to care for injured workers. The South Coast area, one of the common challenges that's shared with me when I talk to the administrators in the healthcare systems down there is that they actually have quite a bit of an aging population as well. And that has its own spike in demand and makes it difficult just in the overall bandwidth. There's a lot of healthcare utilization, and so that's a challenge for them. And then there's other areas where everybody is actually fairly used to traveling a decent distance to get to care because they live in such a sparsely populated area. And again, it just is figuring out how do you get timely access to care when you have limitations with providers. And so some of the things that Majoris has explored with those various communities is good ways to provide support to mid-level practitioners to help supplement and support what they do, exploring the concept of telemedicine, how could that be used to supplement without undermining quality. Work injuries in particular are difficult ones to truly manage in a purely virtual world. Not being able to put your hands on to physically examine is difficult, but we've continued to kick around ideas of there's technology, how can we use it, how can we support, and how can we innovate? So that's a lot of what we do in that sense.
Any other questions from the committee or others? Does anybody have any questions for, Scott, I see your
Scott, real quickly. I'm sure I'll have a ton of more questions as we, continue to delve into this extremely complicated and interesting system. But I did want to thank you, especially for that final slide of trying to plug everything into the MLAC lens. I know I've really beat the drum on that repeatedly in the past, and that was really great to see. I think that's really helpful for me to help kind of frame things. So I did want to thank you for that.
That's a good comment. Thanks. I guess maybe, since you're sort of representing the overview, Anne, is there anything, being an expert on managed care and it, does help control costs, is there anything that is a challenge for your industry that makes it difficult to, do the good work that you do? I mean, is there any recommendations for, I don't know, legislatively or administratively to improve things?
Well, right now, I think it's the challenge that we're all facing, and it's a pandemic, and it's a strain on the overall utilization of the healthcare system and medical provider burnout. And I think it's important for us to recognize everything that is asked of medical providers and remember that workers' compensation, by nature, we have a weird Frankenstein hybrid of legal and medical. And the best that we can do to support and provide explanations to the processes and provide support to the providers and understanding how to navigate those elements, I think is really critical. And right now, respect for the fact that they have had such a significant demand on them that I think for the next couple of years, they're going to need even more support from us in navigating through what is going to be a significant time of change.
Those are really, really good comments. So I think simplifying is one of the things that's in our work plan. I think that's a word that we use a lot, and that's a good thing to keep in mind. Did anybody have any questions for Mr. Washburn? Because now that you heard the overview, I don't know if you remember his specific comments on Kaiser. Does anybody have more specific questions for him? Scott, go ahead.
Scott Strickland. I guess just a quick question. I know that we've seen a presentation that shows this sort of kind of independent arrangement of MCOs is within the Kaiser network, because I know Kaiser's kind of a complicated, they're a provider, they're an insurer, they're also have an MCO. Is the MCO separated? Or I guess what kind of firewalls and separation exists within the MCO to keep it separate from maybe other influence that Kaiser's insuring branch would have?
Yeah, so we actually sit outside of the insurance branch of the organization. So it's something that we've kind of looked at quite a bit here recently, in fact, to make sure that we do keep that arm length with them. We also treat our own Kaiser injured employees, and so we have to always make sure we keep an arm's length relationship with our Kaiser disability management group as well. So that's something that we do make sure that we keep that distance there. So I think it's a good question, though.
Could you have any kind of specifics of some examples of the firewalls that you have there, either now or follow up email comment or something like that, like separation of board members maybe, or just whatever procedures you have for that? I'd be interested.
Yeah, let me follow up with you. I'll follow up with an email on that one. But I think it's a good question.
Great, thank you.
Yep.
All right. Any other questions? Hey, well, thank you very much, James, for attending today. We have two more presentations. The next one is from Caremark Comp, Managed Healthcare Northwest. We have Dr. Jennifer Lawler and David Pyle representing them.
Hi, I'm David Pyle, CEO at Managed Healthcare Northwest, Caremark Comp. I've worked at MHN for over 30 years, holding additional management positions in IT, finance, and HR. Our MCO, Caremark Comp, was formed in 1991. We contract with over 2,000 physicians, 1,500 non-physician practitioners, and 17 hospitals. We operate in geographical service areas of Northwest Oregon, including North Coast, Portland Metro, Salem, and the Dalles. And our goal is to facilitate appropriate care with a shared goal of restoring as much function as possible to injured workers adherent to standard treatment guidelines. I brought with me Dr. Jennifer Lawler, our medical director, and thank you. You did a fantastic overview. Our thoughts were that I would bring in Dr. Lawler to probably talk a little more about fine details from the medical perspective. So I'm going to turn it over to Dr. Jennifer Lawler.
Yeah, actually, Anne, I just want to thank you as well. That was an excellent overview, and we knew that was coming before our presentation, so we just kind of decided to keep it short and sweet for our part. But I can just share a little bit. I'm a physiatrist, physical medicine rehabilitation, and I'm the medical director at Caremark. We have an additional medical advisor, Dr. Franklin Wong, who preceded me as the medical director at Caremark. And I'm actively involved in all the different steps that Anne outlined in terms of utilization review and the dispute resolution. And just as she indicated, I'm sure each MCO has a slightly different process, a slightly different name for the review board. We meet on a monthly basis to process appeals, and we have a diverse disciplines represented on the committee. But there is a lot of collaboration and education with providers on the panel. I mean, that is definitely what I see my role as the medical director is to be a very neutral party to try to move things along. As somebody who's still in private practice treating injured workers, and I've been doing so in Oregon for nearly 25 years now, I hope that I offer a very collaborative approach when I reach out to different providers and help them problem solve, explain the rules of work comp, and lead them to different pathways to help their injured workers. And it's that one-on-one education that I find the most useful with providers, rather than providing them opportunities to go listen to a lecture, because I don't think they would attend. Keeping people interested in treating injured workers is also one of my personal goals, because it is burnout is rampant amongst providers right now. COVID did not help that at all. And whenever I'm given the opportunity, I'm trying to promote just engagement amongst providers at all levels to continue to be willing to treat injured workers. I think that having a wide panel and helps us maintain access to the best quality providers for injured workers. So yeah, much of what Ann said, that is the Caremark mission as well. We overlap service areas a little bit, but I see myself as a resource. So I hope any of you and any of the injured workers or providers that have questions reach out to me.
All right, well, thank you. Yeah, is there anything else to the presentation, or is it time for questions?
Time for questions as far as I'm concerned, yeah.
Okay. All right. Scott Strickland is first up.
Yeah, Scott Strickland. Just, I think a couple quick questions that I'm kind of ensuring that I'm grasping how the system works. So the insurers handle a lot of the compensability issues or the kind of money side of things, and MCO, the idea is to separate out the medical decisions so that the MCO is sort of reviewing and making decisions on the medical issues and treatment plan. Is that a fair?
That is fair. It's very much a focus on the clinical treatment that's being proposed or the diagnostics that are being requested, and comparing to standard guidelines. We use a lot of official disability guidelines because that is really specific to work comp, but we're not held to that exclusively. It's really about walking that line of what's accepted condition. We also will look at what is a claimed condition, but careful to indicate to the provider that while this might be clinically appropriate for you to proceed with this, there's not a guarantee of payment because it's not an accepted condition. So there's sort of this ongoing education of making sure that the right next step can happen for the patient, but within the confines of the work comp system.
And sort of thank you. I think that helps. And sort of a follow up to that. So it sounds like there's a little bit of maybe lack of overlap or overlap in how the messaging works on those issues. So is there some clear notice? I know that there's a lot of talk of education for the provider of what is and isn't compensable versus what is and isn't kind of medically recommended or necessary. Is there that same education and notice provided to the injured worker as well, that there may be, you may be receiving this treatment, but there may be kind of compensability concerns about that? Are there kind of protections built in for that, or is that maybe somewhere where there could be some better education and outreach?
That's a good question. I'm not sure how much of the specific information gets directly to the injured worker, or if that is left to the treating provider to explain, which, as you know, may or may not happen with all the time pressures. And even when information is shared directly with the injured worker, it's, there's different levels of medical sophistication out there. So I do hear what you're saying, and I think it's an area for potential improvement. As so much of what we do in medicine, it relies on good communication. I don't know if Ann, if you have any other comments on that.
Yeah, I could just add, at least for the Majoris decisions that go out, there will be a statement in there that says it's approved as medically necessary. You'll want to check with your adjuster to confirm it's compensable. So there's that on any decision that goes out, we have that clarification. The adjuster, I think, also has a role in educating the worker on how benefits are administered. And we also, there's a benefit as well with, by providing the medical necessity decisions at the time that it's requested. Sometimes a claim may be in a deferred status. It hasn't been determined compensable or non-compensable. And once that decision is made, let's say they requested a surgery at the time, only a strain was accepted, and then later there's additional conditions claimed and accepted, where now we already know it's medically appropriate for that diagnosis. Now we've got the decision that it's compensable. There's no additional work to be done. You just move forward to the next step. So I think there are some good layers there. And then any time that the insurer has already made a decision that a condition is not compensable, in other words, they've denied it, because that compensability decision has already been issued by the insurer, the MCO then simply says, we're going to decline to review. This is not real, we know this isn't compensable, and so it's outside of our purview because we are work comp only. So there's a couple little layers there. But there's always opportunity to review. I think transparency is key.
I think that's a great summary. That helps me a lot in visualizing it. If there'd be any way possibly to get like a sample notice that a injured worker would receive, just kind of the form or an example or something, I think that'd be really helpful as we kind of review. And I know part of our work plan is talking about sort of, worker education and things like that. So if we could see what that notice looks like somehow, I think that would be really helpful. And then it sounds like a lot of the review process for, sort of the appeal process within the MCO, that takes place all in-house, correct?
Yes.
Yeah. Great, thank you. I know that was 5 different follow-up rapid fires, but it's very helpful. I appreciate that. Thank you.
Okay, I see Ryan Hearn has.
Yeah, thank you. Caremark, I know you mentioned that you have some overlap on coverage around Oregon with ANS. Do you come down south? Are you South Oregon or?
Our area extends to
through Salem,
Silverton, into parts of Salem, but not further south at this time.
Okay, thank you.
I had one question. Dr. Lawler, you mentioned that attracting physicians to treat injured workers, is that an issue? Or is there a problem? And do some doctors not want to treat injured workers?
Yeah, I would say a lot of providers are not terribly interested. And it really is because it is that medical, legal marriage. And it just kind of makes most physicians squirm a little bit. I think once, with a little bit of hand-holding and a little bit of education, they tend to come along. I think it's also really challenging for a lot of primary care providers because they recognize that there may be a difficult decision that's difficult to explain and it's difficult for the injured worker to understand, when they are trying to sort of navigate that the strain is completed and this may be more of your chronic condition. And so it does make it difficult, particularly those smaller communities. They've got this long-standing relationship with them. They're the only provider in the community. And that's where, truthfully, I believe the MCOs can be very helpful in those settings because we can be that neutral party to sort of help diffuse that a bit in a way that is, I think, productive and adherent to, the intent of what workers' compensation is supposed to cover. So it is challenging. There are also different specialties that are just, in short supply across the whole state. So when they're in short supply, they can kind of take their pick of what types of patients they want to see. And since work comp comes with this additional layer of paperwork and responsibility, they sometimes shy away from that. So, I would say, psychiatry is challenging to find, for example, along with psychology. Those are some of the areas that are a little tougher to find providers for. And I would say also care that falls out of the conventional work injuries. So recently, of course, with COVID, that's sort of an overlap. It's like pulmonologists are not really accustomed to seeing a lot of injured workers. So engaging them can be a little more challenging. So there's some little exceptions, but we're always on the lookout for opportunities to reach out and make sure that the panel is whole and that we represent all the different specialties.
That was very informative. Thank you very much. Any other questions? All right. Well, we might have some at the end. We have one more presentation, so I want to give them as much time as they need. And it is Providence Managed Care Organization, and representing them is Jenny Walsh. And I'll turn it over to her.
Oh, hi. I am sorry, I'm having technical problems, so I can't, I don't have my camera on. I apologize. But yeah, I just wanted to introduce our group. We're part of Providence Health Plan. We were also, we were first certified in 1990, and our geographic areas throughout the state of Oregon. We're part of Providence Plan Partners, and we're wholly owned by Providence Health and Services. And we're, our provider panel consists of 8,500 providers, and they are urgent care, hospitals, occupational health, integrative health management, and we have a dedicated UR team that services and ensure services meet eligibility requirements, and every case is reviewed on its merits. If it's denied, the injured worker always has the option of appeal. And we always check for the quality and appropriateness of the care with the objective of healthy, productive workers at the lowest cost. And it's based on ODG guidelines and Providence Health Plan criteria. And we also have a dedicated service team whose main goal is to facilitate the appropriate care for injured workers and to ensure the needs of the injured worker are taken care of. And our end goal, of course, is being successful, providing a successful transition to return to work and maximum medical improvement. And this aligning with the needs of the worker, and this indirectly, of course, pays off with benefits to the employer and the insurer for reduced medical costs. We have a medical director who is also a practicing occupational health provider. He oversees our utilization management, conducts treatment reviews, and he also engages in peer-to-peer calls when necessary. We collaborate with our providers for education and cohesive plans to facilitate injured workers in moving forward with their lives. Our main thing is we really try to work with the injured worker to make sure that they receive compassionate care, that they're appropriately partnered with our providers on panel, and to make sure that they're taken care of and they return to work in an expedited, appropriate manner, and that their medical needs are taken care of. We do also have some access issues in some of the more rural areas of the state, as mentioned previously. And in the Portland area, we also have some access issues with neurologists and behavioral health on the fringes of the state. But we work really diligently and hard to find appropriate medical providers in those cases to make sure those needs are taken care of, the injured worker. That pretty much covers. Does anyone have questions? I know Ann did a wonderful job of providing the overview, but does anyone have questions specific to Providence and what we do as a MCO?
Jenny, there is one. Sarah Duckwall has her hand raised.
Jenny, it's not a specific question, but maybe you want to field it. It seems like MCOs can provide a lot of benefits. Can someone, you specifically or anyone else on the panel, give an instance where you wouldn't want to use an MCO?
Where you wouldn't want to use one. I think in a case where a patient, it's a case that might be several years old, where you wouldn't want, and it's complicated, maybe a couple surgeries or extensive, a history of medical care. You wouldn't want to take that patient away from their medical provider under a scenario like that. You could enroll, though, however, and the patient, we have had cases where the patient will maintain, or the injured worker will maintain treatment with that provider, but the provider will be subject to utilization review and the requirements of our MCO. But that's the only case that I can think of where you really would consider if an enrollment would be helpful for the injured worker. Does that answer that question?
It does. Thank you.
Thank you, Sarah. Any other questions for Jenny? Scott?
Scott Strickland. I don't know if this is, again, specifically for Jenny, but we've heard a couple times now that there are some, I mean, just generally within healthcare burnout and access issues, but within MCOs as well. For the areas where there would be difficulty finding coverage or a provider, what's the way that workers are insured to get the care that they need? Is it that they just, if they live in an area where there aren't providers available, would they just not be enrolled in an MCO? Or they'd be enrolled, but there'd be, come along provisions or some kind of permission for outside of network care given, the extenuating circumstances of not having in-network providers locally? Or what's the procedure for that or the process for that, especially in more rural areas?
I can address in terms of Caremark. We play a really active role in helping injured workers try to find an attending. So we make ourselves available. If they call, Jerry Soul here will help the provider find, based on geographical location where they work, what's the type of specialty they need, and try to help facilitate that so they're not left hanging. But I do believe there needs to be given a choice of several providers to help them. We're not really in the business of trying to steer them to just one particular provider, but we're just really trying to help them get plugged in. I would add actually back to the prior question too about when would you not think of using an MCO. I mean, basically for the really straightforward cases that are just going to resolve, within a few weeks, there's not really the need. The more complicated, probably the more helpful the MCO can be, because those cases can go really sideways and drag on for longer than they need to, which we all know can just lead to more disability and more suffering. So just to follow up on that.
I can add too, just from Majoris's experience in the rural communities, it really is a spectrum. When you're saying somebody needs help getting in, you're going to want to look first at the whole set of what are the needs, what are the challenges, what does the area look like. There will be times where we're able to facilitate, access into a nearby community where it's reasonable to drive and travel, an appropriate specialty. Also very common for us to be open to partnering with a non-network provider, with just looking for them to agree to collaborate and follow MCO protocols. That's probably the most common. But it is a little bit of a spectrum, because the goal is to say, what does this individual need? But generally, when we have a request for assistance into getting established with a network provider, we go through a process where we do a level of care assessment, and that's done by our physical review, our physician reviewers, to help make that determination recommendation, provide guidance of what's appropriate, including non-network care would make sense in this case, kind of stuff.
Right. There might be a level of expertise, say, a surgeon that there's only one in the area who has that level of training. And, that's the kind of case that I'll review and confirm that and make sure that that is in fact the case, and then justified, and we authorize that.
All right. Well, thank you. That was a good question. Any other questions? I guess for anyone in the group, as we've heard all the sessions now. I have one hand raised, Theodore House. Hope I'm saying that right.
Yeah, Ted Hoyce here. So I represent workers and a partner at Quinn and Hoyce. And so I just had a couple of questions for either Dr. Lawler or the CEO, but I don't know if he's still here. My first question is how a disability prevention consultation sort of plays a role in the MCO process.
Yeah, I'm happy to take that. So basically, the disability prevention consultation, or DPC, is either requested by an adjuster when they're seeing that there's just not real forward movement. Perhaps the patient isn't improving, or they're not advancing their return to work, and it's not really clear from the medical records why that is. And I think once the injured worker is represented, the adjuster doesn't have the same communication to perhaps have that conversation. But, I will be given what the adjuster's concerns are, and that's sort of a initial platform to reach out to the provider and find out what's going on, what's their thought process, can they commit to a plan? Just because sometimes I think the providers get a little bit lost in their own, where the case is going. It's sometimes hard for them to step back and take an overview. So just sort of helping to guide them to come up with a plan. I mean, not putting a plan in words in their mouth or anything like that, but just, it could be a sounding board. Other times when I'm reviewing treatment requests, it just looks like, they're treading water. They're not going anywhere. Maybe they need to take this different route, and I can just propose that idea to the attending, and they either like it or they don't like it, and that's fine. But it might be something that they just don't have experience with, or they haven't thought of, or they don't have the advantage I have, which is really just sort of have all the records right there at my fingertips, and I'm spending time digging down. I think that a lot of providers don't have access or don't take the time to look at say, for example, the physical therapy notes in great detail, to actually look at how many degrees of improvement, what % improvement is that? So that's the disability prevention consultation. It can be difficult to get a hold of the providers, and then, but once we have that conversation, we summarize that and send it back to them so they have a point of reference. And if there isn't follow through, we might do a follow-up phone call afterward. I mean, that's what the MCO is looking to see. Did that all happen as planned? And if it didn't happen, can we find out why? Maybe the worker came back and things had really, there was a re-aggravation or something that threw them off course. But that's the basic process. Any other questions, or did I answer your question?
No, I think that answered it. Thank you very much.
Mm-hmm.
Thank you for that question. All right, well, we have a few minutes left, and I know just from the committee members, I would just sort of ask, is there any follow-up? I heard Scott ask for one thing. It was a notice that goes out, a copy of one of those. This is, informational session in support of our work plan. Is there anything else that we want to ask from this group while they're all assembled to provide in terms of follow-up? I'm hearing nothing. I think I heard a lot. I got a lot of questions answered, and I think importantly, I heard who I can ask if I had questions, and who we need to call on if we, as we work on our work plan. I want to especially thank you, Ann Klein, for the great overview. I think everybody complimented you, but it was very informative for me. But everyone that joined today and gave the information. Is there any other business to bring before this committee, Teresa, or anyone else?
No, Mr. Co-Chair. The only thing I could add is our next standing meeting is on May 19th at noon. This will be MLAC's first hybrid meeting, as the Labor and Industries building will be open. So we will presumably be in room 260, but there will be the virtual option as well.
Okay. All right, so May 19th at noon. Mm-hmm. I don't know. I guess it's brown bag lunch. I don't know if you want to eat there. I don't know.
When we get closer to the meeting, members, Kara, myself, Brittany, will send out some information for you on that. Additional information if you are participating in person, such as reimbursement or providing you a parking pass for the meeting.
Okay, well, I'm going to do everything I can to go. I look forward to seeing people in person again. I've only met all of you as little images on the screen, so I look forward to just seeing how that all goes. So Anything else? Any other comments, questions, concerns? I guess I would move to adjourn the meeting, or I don't even know if I need a motion, but I'll take a motion to adjourn the meeting.
So
We'll
moved.
be here for- All right, Scott and Lynn. Any opposed? Okay, so hearing none, I think it's unanimous. And thank you very much for joining us today, and we'll see you May 19th. Bye-bye. 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 19th. Bye-bye.